I'm Dr. Alicia Kleinman, the geriatrician here at Memorial, and I would love to introduce this upcoming video that we have from Chambliss Elder Law Firm. They are a wonderful group of dedicated social workers, lawyers, paralegals that work just with elders, and they are discussing advanced care planning in the setting of dementia. I hope you enjoy it.
We're going to talk today about when you don't know what you don't know, the importance of having a plan. When you come to an attorney to do estate planning, in a traditional situation, there are several steps that you would go through. First, you gather information for your attorney so that the attorney can assess your finances and your personal situation, look at the structure of your family, and that helps the attorney determine exactly what you might need for your plan. Some of the things that go into that might be future housing and financial options for paying for that housing, and how you're going to pay just your expenses. You want to include that as part of your plan. Another aspect that you would look at is, particularly in a case where there have been some signs of dementia, what are you going to do when the person lacks capacity to make decisions? So you want to make a plan for how someone can help with your finances when you lack capacity, and also how somebody can help you make healthcare decisions. So that goes into the plan. And then, of course, as far as end-of-life planning, we want to make sure that everyone knows what the person's wishes are for how they want to be cared for. You can look at things like where they want to be cared for, if they want to live in the home, if it would be okay to be in a facility, and also treatment options, different treatments that you do or do not want. Do you want a ventilator or artificial feeding? And so those are all things that you would consider and go over with your attorney so that you make sure that you set those forth for your loved ones to know those things.
So we are actually going to divide our presentation and what we're going to talk about into the different kinds of stages that happen with people who have been diagnosed with a dementia or Alzheimer's disease. So we are very focused on being proactive and making decisions when folks are still able to do that. And that is really in the early stages. That's when there's a mild change in memory and thinking, maybe some difficulties with daily tasks. We are planning for those future changes at home, evaluating the risks that may come into place when the person has a diagnosis, knowing that it's progressive in nature, and then really getting those estate planning documents in place.
Plan before there's been any mention of dementia, but if that's not the case, to get someone in an early stage and go ahead and be proactive and make a plan is the time to do it, because you have more options, more things we can offer you for planning.
Right.
So if you are able to, if you're in this early stage and you're able to be proactive, what would you include in your estate plan?
So we put together this word bubble, which has all these different things in there: the post, the last will, the long-term care. I often, when we sit down and talk with folks, I feel like they hear the voices, the adult voice in Charlie Brown, wah, 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 wah. You know, it's so much information. It's so much to do. So we're going to actually break it down piece by piece and explain to you what each piece means and why it's important to do each one.
I kind of feel like clients see this jumble when we start talking about these things.
I know, that's exactly, it's like over our heads or something.
It's a big mess. We'll straighten it out. So one of the first things that you want to look at is how are you going to distribute your stuff? Who gets everything when you die? So some of the documents that you might use to distribute your property or to tell how you want things to be given out are a will or a revocable trust. And just having these documents in place will reduce family conflict. There's no argument about who should get different accounts or who should get the furniture, because you've said straight out who should get what. So this ensures that your wishes are carried out as far as the distribution, and then you can also, in some cases, designate beneficiaries on certain assets like bank accounts or IRAs, that will distribute those things to people at your death, possibly avoid probate with certain types of assets. So you want to, create a will or revocable trust that sets forth your wishes, and then also look at those other things that might make it more efficient to administer your estate once you died. And an important consideration in the cases that we're talking about where there may be one of the parties with some dementia is to make sure that you protect that person. You don't want to just necessarily give a person who has cognitive decline property outright, what we call like a I love you will, where each spouse gives the property to the other. You want to create some protection for that spouse that has those needs, like a protective trust that would allow a trustee to manage the property for the person who couldn't do it for themselves anymore. And another reason that you might want to create a trust rather than distributing property outright is to protect eligibility for benefits to pay for care if that becomes necessary in the future. And those are special things that need to be set up in those documents, and you need expert advice on how to do that to protect the person as much as possible.
When we're dealing with our clients, we oftentimes people think of estate planning as what do you do with your stuff when you're dead? But when we're doing elder law planning, we're actually thinking about what do we need to do with your things and your assets while you're still alive, so that that the individual is taken care of. And there are things that are very important rules about how you do that.
So the next thing that you would consider as part of your plan are incapacity documents. And there are two different aspects of that. Generally, you want there to be a plan for who can make decisions for you once you're unable to make those decisions for yourself. And the first aspect that you look at would be who is going to help you with your finances, and then the second piece being who's going to help you with your healthcare and your personal decisions. So a document that you would use to designate someone to manage your finances would be called a financial power of attorney. You may hear it called a durable general power of attorney. And that document appoints an agent to manage your finances. It would set forth what powers that person has. So, for example, they would probably have the power to write checks for you or to get information about your bank accounts, possibly to give gifts if you've done that in the past, set up a trust for your benefit. They would be able to do that in your stead. What you need to understand about a power of attorney document like this is that this document would allow someone to exercise the same rights that you could be able to exercise, but it doesn't take the principal's rights away. So people don't necessarily always understand that when you sign a power of attorney, you're not giving away all your authority. It's a concurrent authority with the agent and with the person who signs the power of attorney. And we do usually recommend that these documents take effect immediately, and then they would continue, if they're a durable power, to be effective once you lacked capacity and couldn't do those things for yourself.
So the next step is to really look at the advanced directives for healthcare. And in this way, I often say that these documents are kind of a gift. This is a gift to your family because it appoints a legal agent to make your healthcare decisions, but it also indicates what end-of-life treatment and life preferences you have for the time when you're unable to do that. So if you are still able to make those decisions, then a doctor is going to come to you individually. But if you are unable to, if the dementia has progressed and you're unable to make those decisions, then you have indicated, or your family member has indicated exactly what they want. And this is really important. This is a standardized form. Each state has a form that can be used, and you need to definitely have conversations about what your wishes are. The next piece is called a post or a post in Georgia, and this is also a standardized state form, and this is specifically about end-of-life preferences, a do not resuscitate order. This is a doctor-signed order where it is either used in the hospital, it can be used if you have one that is signed by your doctor at home and say 911 is called, but you do not want somebody to do CPR, then you would have to have this specific form to show to the EMS when they get there. Otherwise, they are going to go ahead and do CPR, hook you up to the machines and all of that. So this does not replace the advanced directive for healthcare. This works in cooperation with it. I recommend that everybody have this conversation with their physician. It will likely be on your doctor's chart. It will be at a hospital, and it's per kind of incident, right? So you want to make sure that you've had the conversation with your physician about this. The 5 wishes is another guide or document that can be used, and this encompasses more about how do I want to be treated, how do I want to be cared for at the end of life, so end of life planning. Okay, so we work with real folks every day, and we see lots of different scenarios. In one scenario where somebody has their things in place, Grandpa Joe is 92, he has a do not resuscitate, do not intubate. He has that order, that post from the doctor, and he has requested comfort care. He's asked to pass peacefully in his home. His family is allowed to be with him. They hold his hand. They tell loving stories to him. They laugh and silently, they're there. He and his wife and children will be cared for once he passes, and they've known and understand his wishes. This is the way we hope that people make their decisions and make them known. Because the other piece is, just because you have documents doesn't mean that anybody else knows about them. So you really also want to make sure that your family and loved ones know what your wishes are. So we've talked about the early stages. When somebody has recently been diagnosed with a dementia, they're still able to make their own decisions. Maybe they're just having some short-term memory loss. But as we get into the middle stages of a dementia or Alzheimer's disease diagnosis, we are starting to see more cognitive decline. We're looking at moderate changes in memory and thinking. We may see behavioral changes. You may see that a family member who has always loved and trusted you suddenly thinks you're stealing their money and you are, the bad guy. We often see families having concerns about, can they live alone? What kind of decisions do we have to make? Do they need assisted living? Do they need caregivers? And then at this point, we're limiting unsupervised access to driving, firearms, appliances. When we're doing our planning and having conversations with folks, we are talking about these things. Is somebody, are they driving when they shouldn't be? Are they, do they have, are they turning the stove on and forgetting that it's on? So that's that middle stage. Now we're going to kind of talk about, Rebecca and I are going to talk about, what can you do if you haven't done your planning and now your family member or you are in those middle stages?
This is also the stage where if you've done your planning in the early stage or before that, maybe you can implement part of your plan and use those things that you plan for in advance to help navigate this stage. So this is what I was saying about implementing part of your plan. This is the stage in which the family members are going to get more involved and may become the middleman in trying to address some of these things that Amy was talking about that happen in the middle stage where the person with dementia needs more help.
So we often get phone calls that I'm my mom's power of attorney. Now what do I do? What do I do with my mom? So that is kind of that next step that we're going to talk about.
Yeah, so Amy mentioned having the agent or the power of attorney call us. And so some of the things that the power of attorney might do in this situation is to, get control of some of the financial information, determine how you're going to use those things to take care of the person with dementia. Some things that we recommend are, simplifying everything, reducing the number of accounts you have, consolidating the assets so that you can use that for the person's benefit. Look at how things are invested to make sure that you're going to be able to use that money to the best advantage for the person's care. So those are things that the agent or the power of attorney would be able to do since they have those rights designated in that power of attorney to be involved with the finances.
One of the things that we recommend is even in the earlier stages when somebody is doing better is to actually go to the bank with that individual with the power of attorney document, meet with the banker, discuss, kind of what's happening and make sure they have that on file so that they know that the, son or daughter, or whoever is appointed is going to be able to act on your behalf if you're unable to do that. Another thing that we're big proponents of is, kind of streamlining bill paying, making sure that, if it's automatic, online, those kinds of things, because the last thing you want to happen is if somebody's having memory loss is for them to not be paying their, utilities and suddenly there's no water in the house, or
pay them over
and over, which we've seen that as well. Or, a big concern is, any kind of scams or folks taking advantage of elders. This is kind of the stage when we're in those middle kind of stages of dementia or Alzheimer's. That's when this really can take hold. So being able to look at the bank accounts, know what's going in and out. You for sure want to make sure insurance policies, long-term care insurance premiums, those things are on an automatic payment, and that you have indicated to those companies if the payments don't come in, there are, contact my power of attorney, because the last thing you would want is to have those kinds of policies canceled for not paying, and then you can't get it back.
So another thing that you might address in this stage is simplifying your housing and what you might do going forward as possibly the decline continues. And Amy might have some recommendations.
These are some of the things that we, when we start looking at, well, how do I know what's happening? Am I able to? There's so much technology out there now that we're seeing a lot of families who are maybe doing computers, cameras, they're doing, I've fallen and I can't get up buttons, those kinds of things, simplifying the housing maybe the person's no longer able to handle the yard work. Those kinds of things. If you have the power of attorney and you're able to make those financial decisions, you may be able to act on the behalf of the individual. For some folks, it's actually changing the housing situation, saying, this house is too big to handle anymore. We're going to look at, an independent senior apartment or assisted living, or making those kinds of changes as well.
Or maybe the house just isn't set up for them to be able to
age in place.
Use it if it has a lot of stairs or
right. Bathrooms are not accessible, those kinds of things. So I am, and our team is a big proponent of creating a circle of support and knowing who those people are. Are they, who are the family and close friends? Is there religious or, a church or synagogue family? Who are advocates? Often as a care manager, I am part of that circle of support. Are they professionals, paid caregivers? Are there trustees? There are family members who can be the trustees, or there are actually professional trust officers who manage people's finances and the trust for them. Who are the agents and the successors in your plan? The most important thing is really having the conversation. The worst thing is when nobody's talking to each other. Not very long ago, we had a case where the husband and wife named each other. Husband died. Wife ended up with dementia, and she was in a facility. And the person that they named as their secondary was their accountant. Now, the accountant might have been a great person to name for the financial piece, but what was realized at that moment was that they appointed the accountant for both. So he started getting phone calls from the facility about decision making for this gal, medically. He had no idea what to do, and he didn't even know he had been appointed. So please make sure that in your circle of support, it is not the time to be secretive. So these are just some kind of statistics that we look at in terms of how much things are going to cost and what we're looking at down the road. If you have round-the-clock care in home, you're looking at the potential of up to $200,000 for a year. That number just, takes people's breath away. So we also have to look at, what are the ways, and, many folks will say, I want to stay at home no matter what. But we want to be realistic about what that looks like and whether or not that is, that they have the finances to afford that. I always tell people, don't ever say, I never want to go, because that really makes it very difficult on your agent in the event that a decision has to be made. So
and it creates a lot of guilt for the family.
Tons of guilt.
They aren't able to do that.
Exactly.
Now, this is the average cost of nursing home care. You can see the comparison nationwide versus a little bit cheaper in Tennessee, a little bit cheaper in Georgia for nursing home care. This is just for information so you can see sort of the level of
financial responsibility. And the thing is that it used to be that you actually, if you said, grandma needs to go to a nursing home, you could say, I'm going to admit her to the nursing home. But the way the systems have changed over time is that we're not able to just say that. Actually, the sickest and the most infirm are the ones who are in nursing homes at this point. So there are some people who a nursing home will say, no, they're too healthy, even though the family members will think, no, that's not right. So the best end-of-life care planning. 80% of Americans say they would prefer to die at home. I will tell you that probably, I've been doing this for about 30 years. I will say that probably on one hand, I can tell you of clients that just were totally functioning one day, died in their sleep, and just didn't wake up. Most folks, as they age, they become more and more infirm and need to have that next how do we look at care? Is it more aggressive care, or I call it fast medicine versus a slower medicine? Are we looking at symptom relief? Are we looking at hospice care? Or are we looking at being very aggressive hospitalization and moving forward? So we are proponents of looking at, how can we deal with symptom management and do what folks want to do, which is stay at home.
Oh, the final stage.
The final stage, which is in the long goodbye. This is often the most difficult time. Well, I don't know. I think all of it is hard, and we understand that. And our team understands that when we're working with families. But in the late stages of Alzheimer's disease, this is when you see severe changes in memory and thinking. They need help with most or all activities of daily living. They need full-time support. And at this point, you have to, look at what is happening and what is the plan for this individual. If you have not done your planning in the early and middle stages, there's a time when it may be too late, when an individual is not able to sign documents for themselves. So that's when we start to talk about the next step.
And like we said, as we were talking about the earlier stages and being proactive in the earlier stages, the reason you do that is to avoid some of the things that might happen in the late stages when you haven't done that planning in advance and you're not able to be proactive. You have to be reactive to the situation, and there are fewer options that actually are less appealing than doing the planning in the first place.
Right. So there is a time, and the late stage is when the individual, it is too late for them to sign their own documents.
So when you forgot to do a plan, how do you care for somebody who didn't make a plan? We'll go over that. So here's another bubble. The jumble that you see in your head when you're in that late stage and you realize that you need to make some healthcare decisions, you need to manage the person's finances, and there's none of these plans in place. There's no documents in place to allow you to do that. So are there things that you can do in this stage to move forward with a care plan and to take care of that person? And there are. So one thing that we recommend sometimes in these cases to help someone when really immediate medical decisions need to be made are what we call a surrogate designation. Now, this is a designation that would be made by a physician, and this is what happens when the physician looks around and they see that there's nobody that's been designated to make decisions on this person's behalf. This person's not able to make decisions that are in their best interest. In particular, in cases of dementia, they don't even understand necessarily their medical needs to be able to make those decisions. So the physician would be able to sign this form to designate a person that would be able to make those decisions. And what they look to is to find someone that shows an interest in the person that looks like the person that's most likely to act in their best interest. There's an order of preference. This designation is set forth in a statute. So the statute has an order of preference for the person that the physician might designate, starting with a spouse, a parent of a child. Then you would look to other relatives, adult children, possibly a sibling, or just more distant relatives if there aren't close relatives for that person. So this is a form that is more of a short-term solution for immediate things that need to be determined.
And the worst, I mean, the worst case, well, one of the worst case scenarios is when, you know, there are all these people in a hospital room, there's no designation has been made, and this child says, do everything for mom, and this child says, no, don't do it, don't, it's time to go the palliative or hospice approach, and then the doctor doesn't have any, you know, doesn't know which way the individual went. So then that becomes, then the doctor, you know, says, well, we're going to go with this person. This can cause a lot of family strife, and we have seen that, and that becomes very, very difficult.
Okay, so like I said, the surrogate may be a short-term solution or an emergency solution in a crisis situation, but if a person hasn't in advance executed incapacity documents like a financial power of attorney or advance directive for health care, you're stuck with having to go to the court to have someone appointed to do those things when a person with a dementia is unable to make those decisions. So there is a process for this, and a big reason that it's preferable to have done documents in advance is that obviously this takes time. It also is a lot more expense to go through this process. So what you establish is what's called a conservatorship or a guardianship. The designation is a little different in Tennessee versus Georgia. In Tennessee, it's a conservator of the person who makes personal and healthcare decisions, and a conservator of the property who handles the finances. The person has a similar role in Georgia, but the terminology is different. So in Georgia, a guardian handles health and personal decisions, and a conservator handles property. So to have a conservator or a guardian appointed, the first step is to file a petition with the court. And so the person, usually any person who's concerned about the party who lacks capacity, can file a petition, and they would say in the petition that describe the person's condition and why someone needs to be appointed. It would be filed in the county where the potential ward, which is the person with the disability, lives, and generally, generally that's where you file the petition, and the petitioner a lot of times is the one who's asking to be appointed the guardian or the conservator. The process is a little different in Tennessee versus Georgia. I'm going to go over just generally the process in Tennessee. For a petition to be filed in Tennessee, the ward has to be examined by a physician. That examination needs to be recent. The statute requires that it be within 90 days. And you really need the physician to say that they believe that a guardian or conservator needs to be appointed. Once a petition is filed and with the medical exam, they will go and give. It's like filing a lawsuit against the person who lacks capacity. So they'll be served with papers, a summons to court. They get a copy of the petition that was filed describing what was needed, and there'll be a hearing set before the judge. It's not taken lightly to remove someone's rights, so there are a lot of protections built into this process for the potential ward.
So Rebecca, does it have to be a physician? Can it be a psychologist or nurse practitioner?
Now in Tennessee, it can be a psychologist or what they call a senior psychological examiner, which is not defined in the statute, so I'm not sure exactly who that is. But in Georgia, a licensed clinical social worker qualifies, a psychologist or a physician. And the person that does the report or the medical exam evaluation generally will have to be licensed in the state where you file a petition. So if it's filed in Tennessee, it needs to be someone licensed in Tennessee, or in Georgia, someone licensed in Georgia.
So one of the things that you need to understand about this step is that, first off, it is, as Rebecca said, a process, and it is not something that you could say like, gosh, I hate the shoes Amy wears, I think she's incompetent. So it has to be, you have to basically build a case saying that the individual is not capable of handling, not that they're making bad decisions, because guess what? People are allowed to make bad decisions. It's that they are not legally competent or capable of making those decisions. So I think that's really important, is because we often have families who say, my mom is, acting crazy or doing these crazy things. If the person knows what they're doing and they choose to do it, that's different than being not cognitively competent for handling those decisions.
You see that a lot of times when they're giving money away and they don't like who they're giving it to. But
yeah, so you can't just say, we think that is so. That's why it has to be through, a medical professional who says, yes, this person, based on this diagnosis, lacks the capacity. Let's talk for a second, Rebecca, about, is there ever a time when somebody has the powers of attorney in place, but they still have to go forward with conservatorship?
Yeah, I mean, we do see that sometimes, because, like we were explaining, the power of attorney doesn't take away the person's rights. It only allows someone else to also exercise those rights. So one example that we give sometimes is a person with dementia is no longer able to live at home. Maybe they are leaving the house and getting lost, or they just need to be admitted to a facility so that someone can take care of them. But oftentimes they don't want to be there. If there's only the power of attorney can use those documents to admit someone to a facility, but they could also, then go to the front desk and say, I don't want to be here, and check themselves out. So in a situation like that, where someone is maybe not able to make they're making decisions adverse to the person appointed POA who's trying to make good decisions, and they're undoing their good work. So the incapacity documents do also usually include a provision that designates someone that you would want to be appointed your conservator or guardian in the event that became necessary. If you were making poor decisions and you lack capacity and you were undoing what the power of attorney was trying to do that would be in your best interest, then you may still have to get a conservatorship to take those rights away completely so that you can take care of the person. The next step in the process for a conservatorship is that the court will generally appoint what's called a guardian ad litem. This is usually an attorney. The guardian ad litem would go and talk to everybody involved. They start with talking to the proposed ward, and they tell them what's happened, explain the proceedings. They'll ask them whether they want to contest it or not, whether they want an attorney. The person who has a conservatorship action filed against them has the right to ask for an attorney, and then the court will appoint one, or they can choose their own attorney to contest it. The guardian ad litem also investigates all the circumstances by talking to other family members or anybody else that might have knowledge, possibly financial advisors or healthcare providers. They'll look at medical records, look at their bank accounts, see what has been happening in the bank accounts to try to determine what's needed for the person, and ultimately to make a recommendation to the court about whether a conservator is needed and who it should be. And this guardian ad litem is particularly important in a situation where there's family conflict. They may suggest which family member might be the most appropriate to be appointed, or a lot of times in such cases, I would say probably more than half of the time in a case where there's a lot of conflict between the family about who should be the conservator, they'll appoint an unrelated person to do it, to to lessen the conflict. These cases are scheduled for hearing relatively quickly for a court action. A lot of times in Tennessee, they'll have a hearing within 4 to 6 weeks. And at that hearing, the person that petitions for the conservatorship will go and tell the story to the court, why the conservator is needed, who should be appointed, and then the proposed ward would have an opportunity to put on evidence if they wish. The guardian ad litem would make a report to the court, and the court considers all of those things along with the medical exam to determine what should happen with the conservatorship. And if they determine it's necessary, they'll appoint somebody. The person that's appointed a conservator gets official papers from the court. They call letters of conservatorship that have the official seal of the court. And you use that similarly to how you'd use a power of attorney or an advance directive for healthcare. You would show those that special document from the court to any medical providers or banks to show that you had authority and that the person that was appointed a conservator no longer has that authority. And that's what you'd use to make their decisions for them.
One of the things that we really didn't talk about before, but I do think it's important, is that there are some places that do not accept power of attorney as decision makers, and that would be like the Social Security office. If you are acting on behalf of the individual, you have to become what's called a representative payee, or they do recognize conservatorship. They do not recognize powers of attorney. Similar issues happen sometimes in the VA system. So it's important to know, depending on the systems that you're working in, they may have different rules and different things that they look at. So Rebecca, talk about like the hearing in terms of the individual with Alzheimer's. Do they have to show up? Can they not show up? How does that work?
Well,
it's contentious.
The statute provides certain rights for that person that's the proposed ward. One of the rights is the right to attend the hearing. So of course they get the notice of the hearing and they have the option whether to attend or not. So oftentimes we have a hearing and the proposed ward is not there, but this also can be very upsetting to someone who you file a conservatorship petition against. I mean, I've had cases where the person does have dementia, but they do understand, I've been served with papers and they understand that someone's trying to take away their rights. And, given their mental state, frequently they don't understand that they can't make their own decisions. They think they're doing just fine. And you can have a situation where a person asks for an attorney, they come to the hearing, they want to tell the judge what they think about it, and they do, and that is their right. But if they're not in any condition to come to the hearing, or they just choose not to go, it's not required that they attend the hearing.
So one of the things that we hear a lot from families on these kinds of cases is, it's an emergency. We have to do it right now. You have to understand, call the courts and get an emergency hearing. So Rebecca, tell the folks who are listening to this how the courts deal with these cases and what they think is emergency versus what families do.
So oftentimes what my clients think are an emergency do not qualify as an emergency under the law. You have to make a pretty significant showing that there's going to be a serious and substantial harm very quickly to have a conservator appointed on an emergency basis. Because that relates back to a person's, constitutional rights and their right to have notice. I mean, you're taking away someone's rights, and the court takes that very seriously. So an emergency conservator is appointed without giving notice to the person, and there has to be a pretty substantial showing of an emergency to do that. That process of an emergency conservator also has other protections for the person. They're automatically appointed an attorney. There is an initial hearing that happens within 5 business days to determine whether the emergency conservator should have been appointed at all. So there may be a case where you have an emergency conservator appointed based on what's told to the court initially, and you get to that 5-day hearing and the court says, no, that was probably not necessary. We're going to go through the normal process and have a hearing later, and so the emergency conservator might be dismissed at that point. Another one thing that clients really don't understand is how slowly court proceedings go. Like I said, conservatorship proceedings are considered lightning fast at having a hearing in 6 weeks. And when you're in a situation like this, when you need to do some things immediately, 6 weeks can seem like an eon. And clients just don't understand why you can't just go knock on the courthouse door and get things done immediately. And that's just not how this process works. And that's why you do the planning in advance if you can to avoid this situation. This is another scenario. This is more of a crisis scenario when planning has not been done in advance. If you were unable to do that or you just didn't do it for some reason. This grandma, Lily, is 87. She's in the ICU. She's getting all the possible treatments that are allowed because she didn't indicate her wish that she didn't want to. She may be restrained, maybe receiving tube feedings. We see a lot that people will say when they do make their wishes known that they don't want any of these things to happen. And they're giving her all the treatment necessary, not necessarily just for comfort.
And then this ends up being, our goal is to decrease conflict, to increase communication and help folks be able to understand the planning. If that, we also understand that there's dysfunction in families, there are family conflicts, there's all these kinds of things that happen. So we're not unrealistic about that. But obviously, when the individual is now, hooked up to the ventilator and getting all these treatments and things, maybe the body is still there. But now what happens? And this becomes not only the question about what are treatments gonna be? The next step is gonna be, okay, when she does pass away, because it's likely that she will, 87, Alzheimer's disease, on an IC, on a ventilator, all those things, her body is gonna shut down. Is there a point at which the family's gonna have to make the decision to discontinue? If that happens, then what are the decisions about, immediately funeral arrangements, what happens with her stuff? what happens with her, you know, with her, is there a funeral, all of that. And so, Rebecca, can you talk a little bit about, like, if there is no will and the person dies, how does that go?
Well, if you've not made a will, obviously you don't get to choose where your things go, and there are statutory provisions that set forth who gets your stuff. It may not be who you want to receive the things when you die. Generally, if you're married, your spouse will get an interest. If you have a spouse and children, in Tennessee, the first division is that the spouse would get at least a third, and then the children get 2/3 interest in your things. But it designates which relatives will receive your things, on down to, you know, cousins and further relatives, and then ultimately, if there aren't any relatives, the state may get your property.
So let's go back and kind of make this clear again. So if you have a spouse and you die without any of the planning, a lot of people think, well, everything will just go to my husband. That, according to this, they call it intestate laws, right?
Right.
That is not what happens.
That is not what happened. And I actually recently had a situation where a spouse died, and she was under conservatorship. There was no will, and everybody kind of just assumed that the things would go to her husband, but they had 4 children. So instead of getting to use all the joint property that they had, the property they'd acquired jointly over all those years for his benefit until he died, 2/3 of that money had to be divided by the adult children, because there was no will.
Okay, well, we are thrilled to be here with you again. I'm Amy Boulware, and this is Rebecca Miller. And we are easy to get in touch with if you have questions about these things. If you're at the point, hopefully in the beginning, if you're in the middle or in the end, we are available to help you through this process, and we're happy to be that resource to you.
We hope this has been helpful, and that you'll contact us if you need.
Thank you so very much.
Thank you.